Good evening, everyone, and thank you for joining us tonight for Understanding Neurodivergence in Law and Justice. My name is Emma Lanwarn, and I am the co-founder of neurodiversikey. Tonight's event marks the midpoint of our first ever Neurodiversity Celebration Week as an organisation. Let me briefly introduce our speakers for you this evening. It is a pleasure to introduce our speakers, Matthew Graham, who is a solicitor at Stone King, and Alia Lewis, who is a director and solicitor at Duncan Lewis. Amanda Weston KC, who is due to join us shortly, is a barrister at Garden Court Chambers. Tonight's event will be addressing the following questions. What are the biggest threats to justice or barriers for neurodivergent people? We will discuss how intersectionality contributes to threats to justice and the barriers. How can threats to justice or barriers for neurodivergent people be minimised? And what are the key provisions to minimising those threats and barriers, particularly addressing how successful the provisions are? Alia, I first wanted to come to you. What do you think in your area of law is the biggest threats to justice and the barriers for neurodivergent people?
Well, thank you for having me, Emma and Daniel. I think from my perspective, it's quite a simple answer with lots of threads to it, and it's quite simply lack of understanding. Lack of understanding is the basis of all the barriers that neurodivergent parties in family proceedings face. As far as I'm concerned, and that lack of understanding is what's driven the work that myself and my team are currently doing. It might help to just give a bit of background of where I've come from. I've got a child who is autistic. He's 9 now. He was diagnosed when he was age 3. And so I've had 6 years of knowingly being a parent of an autistic child, although he's 9. And I've realised over that past 6 years how little I knew about autism and neurodivergence in general before I became aware of my son's autism and his subsequent diagnosis. And it became apparent to me over the past 6 years how differently I began to practice in my cases. I am a children panel solicitor. I represent children in care cases mainly, although I do represent parents as well. And it also became apparent to me not only how different my practice, but how the other lawyers and the social workers and other professionals in my cases were struggling to understand the issues around neurodivergence. And so really that was the basis for me to start exploring ways of trying to deal with these barriers. And first of all, for me, it was about trying to look at the issue of training, because in the family justice and child protection system, whilst we're dealing with huge numbers of people passing through these systems who are neurodivergent, as we know from, many of us will know from the ADHD Foundation website, 1 in 5 people in the UK are neurodivergent. So you can imagine how many people are passing through the family justice system with conditions that fall under the neurodivergence umbrella. We are not required to undertake any form of training in relation to neurodivergent conditions. And as my understanding of neurodivergence increased, I became more and more alarmed by this. And then I could see the way in which this was impacting on the way in which we advocate for neurodivergent parties, care plan in cases, in care cases, support neurodivergent parties, and the way in which it can lead to, the lack of understanding can lead to issues such as parental blame in care cases, because social workers don't understand the problems that they're being faced with in terms of the child protection concerns that are arising in these cases, and quite often will attribute the the welfare concerns to bad parenting, rather than really digging below the surface and understanding what's actually causing the issues that they're being faced with. So yeah, I mean, that was the most alarming thing to me, that none of us are trained, whether you're talking about social workers, family support workers, solicitors, judges, barristers. Mainly it's training that you access yourself if you begin to become aware that you need that training and understanding. And to be more specific, I mean, in cases that I deal with on a daily basis, like I said, I represent children, and you end up in situations where children can be placed in a foster placement. For example, a severely autistic child can be placed in a foster placement with a foster carer who has no understanding of autism, has had no training, has never looked after an autistic child before. You can have situations where social workers will not advocate for relevant assessments for children because they don't understand the assessments that are required. And I don't say this as any form of criticism to any professional that operates within these systems. I was one of those professionals that didn't understand until I had my son. So you can imagine how, from just those minimal examples, there can flow massive barriers to actually achieving justice in family cases if you're not understanding the needs of the child that you're dealing with, and equally if you're not understanding the needs of the parents that you're dealing with, because many, as we know, many parents in the family justice system are neurodivergent. Quite often there's a genetic link, and so in many of our cases we see that parents that are neurodivergent are misunderstood. They're seen as difficult, and that just causes huge problems in terms of the way the cases progress through court, and the really skewed and inaccurate and unfair narratives that develop as a result of that lack of understanding. And so what we've tried to do is to begin addressing that by developing a specialist team within our firm, and also a working group to try and drive forward changes, which I can talk about later. But the other topic I wanted to touch on on this question is just going back to the parental blame issue. There was a report by the charity Cerebra last year that looked at the prevalence of the prevalence and impact of false allegations against parents of fabricated illness. And I think this is quite a helpful report to look at when we're talking about barriers to justice. When you look at the report, it's quite surprising actually, the figures. They did a study of 387 families. 97% of the parents and carers who responded considered their children to be disabled, and 65% of those respondents identified with children who were autistic or with a non-visible disability. And over 40% of the parents who responded identified as autistic. So this is cases where parents have been falsely accused of fabricating illness in their child. And when you look at the conclusions of those cases, the figures show that 84% of those cases ended in no follow-up action, and 95% of children remaining with parents. And I think that's really important to touch upon, because not only is the family justice system, the child protection system, set up in a way that places huge barriers in place of justice for neurodivergent parties, but there's also the wider implications in terms of guidance that professionals within those systems have to consider. And within fabricated illness cases, professionals have to consider, well, medical professionals, for example, have to consider the perplexing presentation guidance, which is set out by the Royal College of Paediatrics and Child Health. And that asks medics to look at alerting signs. And many of those alerting signs are things like implausible presentations, seeking multiple opinions, repeated presentations to medical professionals. And as we know, those alerting signs and those presentations could very much relate to neurodivergent parents, and are therefore very likely discriminatory. And they then feed into the family justice system, where social workers raise concerns about a child's welfare because of alleged fabricated illness, and so the cycle goes on. And so I thought that was quite interesting in terms of the figures, because it really highlights the need for a massive overhaul of not just the family justice system, but the wider systems that feed into the family justice system.
I absolutely agree, Alia, that the shocking statistics. And do you think, in your opinion, that parents are scared to even raise the possibility that their child may have autism or ADHD because there's such a stigma still attached to these conditions?
I think that parents will raise it. Some parents will raise it. I don't know whether it's that they're scared to raise it, but I think quite often many parents will raise it and they're probably right that their child is autistic and or ADHD and or whatever other condition. But because social workers are not trained to understand the traits and the signs, they are quite often dismissive. And that relates back to parental blame. And there's actually been a study last year by Birmingham. In Birmingham, there was a study. I've not seen the outcome of the research yet, but they're specifically looking at parental blame and autism, which is quite telling. And it was funded by NHS England, which is very telling, which shows that there is a huge problem. Yeah. I mean, as a parent of an autistic child myself, I've not thankfully been involved with children's services, but I can certainly say that when I was finding my way through his toddler years and trying to understand why he seemed to be so different to his peers, and I took him to his 1-year developmental check and his 2-year developmental check, and he wasn't doing most of the things that he should have been doing at those ages. I experienced on a low level the kind of concept of parental blame when health visitors were saying to me, well, Mum, have you tried modelling how to brush his teeth, or have you tried modelling how to scoop a spoon? And it became about my parenting rather than the fact that there was actually, what I didn't realise at the time, very clear and obvious signs of autism that he was presenting with. But because I didn't understand, I wasn't able to advocate for him at that time. I was just questioning, why is he not doing these things? And so having experienced it on a very low level, I can only imagine how deeply frustrating and also traumatic. And that's one of the things that came out of the FII study, the Cerebra study, was the trauma that these families experience, particularly in FII cases, of being accused of fabricating illness and problems in their children when actually they haven't. And it must be hugely traumatic. I mean, it has really, really serious implications, because parents who are accused of fabricating traits or illness or whatever it is, they don't want to then go and ask for support. And then again, that gets them into a really dangerous cycle, because if you're not getting the support you need, the problems are going to exacerbate, and then you're more likely to come to the attention of children's services.
Yeah, and if you're not getting the training, how are you going to recognise, those signs and symptoms and how to access help?
Exactly, and it's a
never-ending cycle.
Exactly. Yeah. And the lack of understanding is across the board, and it's not just social workers, it's everyone in the family justice system, and it's really important that really experienced and established people within the family justice system, judges particularly, are able to accept that whilst they may be amazing lawyers, there are things that they need to learn, and we're always able to learn more. We're always able to improve ourselves and our knowledge, and that there is a massive gap in what we've been taught. A huge proportion of society is neurodivergent, and this is something that's really got to start being accepted by the professions that fall under the umbrella of the family justice system, that we need to learn about this, because this is brains wired differently to what is expected and what's considered typical, in order to make sure that people are actually getting the justice that they deserve, and that children are getting the outcomes that they deserve.
Absolutely agree, Alia. And just when you said that, it affects all areas of law across the board, I just want to move on to Matthew. Matthew, what do you see are the biggest threats and barriers to justice for neurodivergent people in criminal law?
It's a big question, Emma. I suppose as I frame an answer and think about this question, I see it in two regards. I ask myself about the points of entry into the criminal justice system, whether that's as somebody accused or an offender or a perpetrator, or whether it's as a victim or a witness of crime. What are those drivers into the system? I think we need to think carefully about that when we're considering the impact of neurodivergence on the criminal justice system. We know statistically that the neurodivergent community are overrepresented in the criminal justice system, both as perpetrators and as victims, and so probably as witnesses as well, therefore. So we have more of the neurodivergent community in the criminal justice system than the general population. So I think we have to ask ourselves really important questions about why that is. I don't have the answers to that, but when we think about the threats to justice, I think that's a really big part of the answer in reality. We tend probably as lawyers to talk quite a bit about picking up the pieces, about how we deal with policing, about how we deal with courts, about how we deal with prisons. But of course, all of those people come into the system at some point. For my own part as a professional, I think there's actually an over emphasis on defendants, on offenders and perpetrators, to the extent that there's a lack of focus on the importance of neurodivergence for victims and witnesses in the system. It's my own experience comes through there. I might potentially get public funding, for example, to help a neurodivergent offender, but there's no equivalent for a neurodivergent victim. And they are, I'm afraid, treated poorly in the system. That's the stark reality of it. Rosie, I can't see you, but I can see the comment that you've made, and it's telling that you're surprised that there's not training in relation to neurodivergence for practitioners. You're right, there isn't. You should be surprised in that sense because it's rubbish, but it's true. As an advocate in a magistrate's court, in a Crown Court, across the system, there's no requirement on me as a professional to have any training in respect of this whatsoever. And so I can go and cross-examine witnesses or victims at will without any of that knowledge or experience. I'm afraid that is to the significant disadvantage, ultimately, of those who deserve better. But we also look at the experience of those in the system, and of course that is part of the focus. And I'm afraid the experience of the neurodivergent community in the criminal justice system is poor. There's no question of that. I've been practicing since a bit before 2000, so I've seen it over the last 20, 25 years or so, and I don't see any significant improvement. I mean, that's the reality of it. There was some basic guidance for police station practice in 2000, and there is some basic guidance now. And that's not through a lack of effort on some people's parts, but it does show the enormity of the challenge, I suppose. You know, I think if I were to pick out a couple of points which for me are real threats amongst a lot, I think policing is a real headline for me, because this crosses over between the experience of victims and witnesses and those accused and who become defendants. Because the reality is the experience through policing is really not good enough, and that needs saying and it needs acknowledging. That's my view, but it's a view that's shared quite widely, including in policing in many circles. It just hasn't become a driver of change as yet. But it's a significant threat to justice. There's a lack of understanding. Alia refers to that as a key point, that lack of understanding. I echo that. That mirrors my experience of going to police stations, talking to police officers on whichever side it may be in a particular moment. Those experiences are not good enough. And that's a real threat to justice. And I see injustice because of that lack of understanding then flowing through the system. I think the other area is when we come to try and understand the seriousness of crime. The law, statute tells us that we must decide the seriousness of crime by balancing the culpability of the offender and the harm caused. So if you want to work out what somebody should get for committing a crime, you have to understand the seriousness, balance harm and culpability. And our sentencing guidelines tell us that's what we should do. The law tells us that's what we should do. And that's what happens day in, day out in court. You wouldn't think it, though, if you went to a court and watched a case, criminal court and watched a case. Because I think the assessment of culpability when we're talking about neurodivergent offenders is a really complex topic and misunderstood and ill dealt with in many cases. And I see that in my practical experience, and that's a real threat to justice. There's a sentencing guideline on this subject, which is little used in practical terms. Lip service is often paid. I am critical of it. It's not because people aren't sometimes doing their best. It's just hard. But the fact that it's hard doesn't mean that it's not a threat to justice. It massively is. And I think assessing the culpability of neurodivergent offenders is an area where we've got a massive amount to do. I am sure that there will be a time, I hope in my lifetime, I don't know, when we will look back on now, on 2024, and shake our heads at how we dealt with those with significant neurodivergent presentations in the way that we might look back on, I don't know, Victorian England and wonder what asylums were about and so forth. I think that time will come when we look at 2024 and think that it was completely unacceptable. I hope, as I say, that's in my lifetime, I'm not sure, but I hope it is. It's a real threat to justice that fundamentally, as a society, to what extent do we blame individuals who commit crimes? That's at the heart of measuring seriousness. And I think neurodivergence is poorly understood in that context. And I think that brings together what you were saying, Alia, as I listened to you about family justice, justice for children, ultimately through that system to make sure that they're the most vulnerable, that you look after, I suppose, or try to advocate for within the system, the most vulnerable. Well, when we deal with the most vulnerable, the measure, is it not, of our justice systems? And that might be because of their age, it might be because of their mental health, it might be because of their neurodivergence, or often all of those things in some combination or another. And I'm afraid I think we stack up poorly at the moment.
Do you think, Matthew, the questions around neurodivergence are not being asked crucially at the police station stage? Because obviously that's the start of the cases at the police station. Now, if the questions are not going to be, if they're not asked because the person doesn't know, has no knowledge of it, there's no signs or symptoms that they're aware of, do you also think that impacts?
Yeah, so if anyone's ever given a statement to the police as a victim or a witness, for example, the police literally have a piece of paper form that they will typically write it down on by hand, or if they're using a computer, an electronic version of it. And on one side, the statement gets written out, and on the back of it, there are some questions for that individual about support they might need if they go to court. There's not a question in relation to neurodivergence. So there's no prompt.
Is there anything that you've seen on any custody records, or should there be, in your opinion?
So there's no question about it specifically. It's lumped together with mental health in that sense. And I can understand why that is, but it's wrong. There should be specific questions and prompts, and there aren't. So there's one example of where there's an obvious weakness that could easily be addressed. If every person who gave a witness statement to the police was specifically asked about whether they wished to bring to the attention of anyone looking at that statement that they have a neurodivergent presentation of to some extent and could be supported through that, our system would be more just. That's the simple reality of it. Why don't we ask for them? Is it because people don't care? Is it because you just haven't got there? But there are simple steps that can be taken. It's easy for Alia and I to sit a little bit on our high horse with this, I suppose, and bemoan the system. But at the front line, small steps make a big difference. That's my experience. Caring is a start, and asking the question, therefore, is important. And I mean, it certainly doesn't arise in custody environments at all for those accused who have been taken into a custody environment. Actually, to some extent, even more so for those who are in a non-custody environment, dare I say. But
what about in your practice, Matthew? I mean, do you make a point of asking the question about neurodivergence in case prepping, taking instructions before first appearances, trials?
Yeah, absolutely. And I think this doesn't sit in isolation, of course, Emma. One needs to understand the individuals that we're working with. Law's got a lot of books, a lot of boring law involved. Lawyers are boring in that sense. But at the heart of the work that I do, I think it's the same for Alia, at the heart of our work are people. And there's no point in understanding the law if you don't understand the people. That's my view. And there's no real exception to that. If you don't understand the people, then you won't understand the legal context. And I think this idea of context is particularly important when dealing with neurodivergence, because what amounts to a strength or a weakness is very context specific often. And it may well be that I'm working with quite a high performing professional whose neurodivergence has been a real strength, for example, in their professional career. But those same strengths might become real weaknesses in, for example, a custody environment or where there's an unfamiliarity. And so I think understanding the person is understanding the law. And if there are gaps in your understanding of the person, there will be gaps in your understanding of the legal framework that they're working in.
Very true, Matthew. Rings so many bells, so true. I just want to move over to Alia. Just in respect of you both, you've highlighted the lack of understanding of neurodivergence as part of both of your work. And part of our work is to make the legal profession neurodiverse and obviously, therefore, representation. If the legal profession did become truly neurodiverse, what do you think, Alia, would be the impact on neurodivergent clients, first of all?
I think the legal profession, actually, I think there is a lot of neurodivergent people within the legal profession, I have to say. I just didn't understand it until I had my son. In terms of the characters that I regularly come across in my practice and at court, and I understand it so much better now. But I think that people get caught up in their own bubbles and their own lives, don't they? And there's so many people now with the things that I've been doing to try and change things within the family justice system that I'm getting an amazingly positive response from people who are either neurodivergent themselves within the profession or have a family member who's neurodivergent. But it just takes someone to kind of spark the light, really, to say, right, well, let's change things, and then people will follow. And so I think it was just, I think for me, just seeing the difference that support and the right intervention has made for my son made me realise that I had to do something. And I think now people within the profession who are neurodivergent, when I say profession, I mean within the family justice profession, are starting to realise that they can actually do something to help change things. And so what we've done in our firm, myself and a couple of my colleagues who are actually joined tonight, we've developed a specialist autism and ADHD team within our childcare department at Duncan Lewis, to be able to provide a really informed and bespoke service to our neurodivergent clients. But alongside that, we've developed this cross-firm working group with Beck Fitzgerald Solicitors and Coram Chambers in order to form a basis to drive forward our campaign for reforming the family justice system. So if anyone who's interested can have a look at Flank, which is FLANC, flank.org.uk. And really what we're advocating for is compulsory training, best practice guidance, and systemic change. And one of the things that we're looking at within those changes is what Matthew was talking about, which is to actually ask the question about neurodivergence. So when a local authority first issues a care application, when they're seeking an order in respect of a child, on the form they have to answer whether there's any issues of disability, but it's a very wide question, and there's no question about neurodivergence. So one of the things that we're saying is there needs to be a question on that form about neurodivergence, but not only just on that form. Once the case is issued and standard directions are issued by the court, which happens on every single case, that standard directions order needs to also ask the question about neurodivergence, so that by that point, the parties are involved, they will have all instructed their lawyers. So the lawyers are then thinking about whether there's an issue of neurodivergence to consider. And even if someone isn't trained and they don't fully understand it, the mere fact that that question is there will hopefully encourage people to at least think about it. And then it may mean that people get the support that they need and the assessments that they need, and etc. But I'm hoping that the many people that I know amongst the solicitor and barrister profession who are neurodivergent will get on board and help push forward this campaign, because it is so important.
It sounds absolutely fantastic, Alia. It really does, and it will make an impact. Just even asking the question, I think all of us on the call, we ask the questions and we know that it truly impacts. I think another important aspect to highlight is representation. I work as a paralegal preparing the cases for criminal defence, and very often my clients will say to me, you don't understand, you don't look like us. I say I've got ADHD and I'm dyslexic, and they're absolutely shocked because I don't look like I have it. And then I say, well, what does it look like? And it's absolutely amazing when you just have that representation. It just opens up a whole new communication channel for that person, because in my experience, they feel heard, they feel listened to, and you can actually understand and explain the process for them to understand and participate effectively. Because as we know, and I'm sure Matthew would agree, the court system just isn't able to effectively help neurodivergents participate, and sometimes they're labelled as obviously lazy or not interested, and that's totally not the case. I mean, Matthew, what do you think would be the impact in criminal law if we did become truly neurodiverse?
It's a complex question, this, Emma, and I think plainly the legal profession would be better off if it was more representative, and that's true in neurodiversity as it is in many different areas. But I suppose I might express somewhat of a counterpoint to that, insofar as a concern I have about neurodivergence is it's sometimes seen as a topic that other people deal with. And I think therein lies a real weakness, because actually it's something that in the criminal justice system, all advocates, all representatives need to be mindful of and to be aware of, need to be better at, frankly, as opposed to being, this is something that's done by autistic lawyers, or this is something that's being done by dyslexic lawyers. And likewise, those autistic or dyslexic lawyers, or it may be, may choose to work in whatever area of law they want in that sense. So, and I observe myself amongst my colleagues and amongst my fellow professionals, a lot of fear around neurodivergence. What words do you use? How do you not offend somebody? Are you going to say the wrong thing? Are you going to use some language that upsets somebody? And the language of neurodiversity is not easy. I say that as a professional advocate in that sense. And I think that's off-putting. Does it mean that you say nothing or do nothing? I think often it does. And I fear that. So, although plainly having a more diverse legal profession would plainly be a good thing, and it is a systemic barrier, as it were, for the neurodiverse community in accessing justice. In the immediate sense, I think there are practical steps of the sort that Alia has been talking about introducing, as it's which really are a big priority for us as lawyers, whoever we may be, and indeed whoever we are representing in that sense. So it is that practicality that I suppose I advocate. I want to hear more of those voices. I want to hear more of those immediate experiences of individuals to be able to come into the justice system. And how is their neurodiversity, if at all, impacting them? B, there on the question asked whether there's an obligation to disclose that information. Well, no, there isn't, but there is an opportunity. And I fear it's the opportunities that are lacking at the moment. And how somebody wishes to describe themselves, as far as I'm concerned, is a matter for them in that sense. But I know from my practical experience, and I see this probably daily, there are people who are not able to say what they want to say because they fear prejudice, or they feel that they'll be misheard or misunderstood in some way. And it's a real area of difficulty. You know, as a practical example, Emma, I'm struck by how often I'm contacted by the family member of a neurodiverse accused, for example, in big criminal defence practice, as compared proportionately to the non-neurodiverse. Well, what is it about our own services that are making it hard for those individuals to reach out themselves? It's a practical day-to-day experience. Rosie, you describe yourself as a former police officer in that sense, but I'm sure you would have experienced yourself the same thing. Why is it difficult for an autistic victim to come forward? What are those barriers? Understanding those and doing something about them in practical terms seems to me to be a key topic. And having more neurodiverse lawyers will help with that. But for me, it's not necessarily the focus at the moment. There's a practicality involved in this. Let's get that opportunity for those voices to be heard. This is in the context of the justice system that we're talking about this evening. And the justice system, I want those opportunities to be better for those people to be heard wherever they may be falling.
Thank you, Matthew. And that just brings me back to your own practice. How do you tailor your practice to neurodivergent clients?
Number one, listen. It's a starting point. Is it always the same? The service that we produce, is it always going to be the same, or might we do things differently with that individual depending on their circumstances? To listen is a really key topic. And if we're looking at systemic challenges within the system, take legal aid franchising, legal aid contracting, which has a single defined degree of service for a single cost, actually. And if you provide legal aid services, you agree to provide those services in accordance with that contract. You have no choice. There's no alternative contract, as it were. You must provide your services in accordance with what is a single standard of best practice. Well, how does that plainly discriminates against those who are neurodiverse, very obviously, in black and white terms, if you read the contract in that sense. And so listening and then doing something different is a key mantra in my practice. Listening is a good start, then do something differently that's better. I think so that's first. The second point is being a confident advocate for neurodiverse clients. Call it out in other areas of the work that you're doing. For me, in the criminal justice system, if I go to a police station with an individual and the way they've been treated isn't good enough, you have to say so. You have to say so then, and you have to change it then. It's not enough to complain about it afterwards. You have to do better then. If you're going to go into a courtroom and I have a client with a particular need, I can't just accept that it's not good enough. I have to do something different. And if that means telling the court that it needs to change its layout, that we need to have a walk around, that we need to arrive at a different time or depart at a different time. If that means I need to speak to security staff to have a different process from literally getting into the building, then so be it. I work in the real world and I can't change it all in that sense. So we work within restriction, do we not? But it's not enough to sit there and accept it and say, well, that's just the way it is. Well, maybe, but maybe not. My own experience actually is if you do call it out and you do try and make a difference, ultimately you do. I mean, that's the reality of it. And as a lawyer, we should be aspiring confidently and ambitiously to actually making a difference to the practical experience for those individuals. And Alia, you'll, I'm sure, reflect on this. Caring about your client, as it were, or that child is one thing, but you still need to ultimately try and make a difference to the way that they're represented through the process to ensure the outcome is better. And I think that there's those two strands to it, Emma, that I see that are really important. You have to listen, you have to do something differently, but you also have to call it out.
I absolutely agree, Matthew. Absolutely. Alia, you have set up a specialist team, and that's come off the back of your own experience. But how do you tailor your practice for your neurodivergent clients?
Well, can I just pick up on one point that Matthew was talking about earlier in terms of language, and then I'll come on to that. One thing that's really struck me over the past few years, and going back to the fact that I've realised that many of the people that I work alongside are neurodivergent, is being a parent myself of a child who's autistic. I've realised how much language really affects me personally. So when I hear people saying about a barrister or another solicitor, oh, they're a bit odd, or they're a bit difficult, or, you know, making comments like that, as soon as, I mean, because my ears are pricked up to it, because I'm more aware, because I've got an autistic child and I'm in that world of, you know, neurodivergence, and have a lot of friends who have children who are autistic or ADHD. It really impacts on me personally when I hear comments about other lawyers. And quite often I'll look them up. I'll look up their profiles to see if they've mentioned that they may be autistic, or they may have ADHD, or maybe dyslexic. And quite often they are. And I think, wow, we really need to do something about that, because that is discrimination. You wouldn't comment on someone's race, but it's okay to make comments like that. And people make comments like that across society, and it's considered okay, but actually it's not, because you're talking about someone's makeup, you know, their biology. And so I think that's one of the things that we really need to start becoming more aware of in terms of the way we talk about people. But in terms of the way I've tailored my practice, there's so many different ways. I mean, first of all, the biggest change to the way I practice is that I think every client that crosses my path, whether it's a child or a parent, I will immediately ask myself, is there any neurodivergence here? Because, as we said at the beginning, when you're looking at 1 in 5 people in society, if not more, being neurodivergent, you should be asking yourself that question for every single client. Not to try and label people, but to be fair and to treat people equally, actually. So that's the first thing. Secondly, we really try to understand so when we understand that a client is neurodivergent, we will make every effort to really understand their personal neurodivergent profile, to really understand their functioning, whether they've got any communication needs, any sensory needs, whatever their needs are, to really be able to tailor the way we communicate with them. So, for example, we've got one client, a parent who wants emails color coded. So if something's really urgent, she wants it in red font. If it's not so urgent, she wants it in green font. It has to be in size 14. And we remember this stuff. We make sure that we remember this stuff, because if I was that client, I would be wanting my lawyer to treat me like that and to make sure that my needs were being met as required, right? So we're really, really meticulous about that. We also,
and that client will feel that you know, they've been listened to by you, just taking on board what
exactly.
they said and actioning it. That is what it is, actioning.
Yeah, and I cannot tell you the amount of parents that have called me And the minute they understand, whether it's me or one of my team, really get it, they just burst into tears. Because so many people don't get it, they're just relieved that someone understands them and someone realizes they're not a nightmare difficult parent, they're actually just neurodivergent, that's all, and they just need to be understood. So that's one part of it. But also really understanding needs to be able to advocate for proper assessments. And the other side is developing our child practice so that we can ensure that when we go, because as children's solicitors, we have to go and visit our child clients. We represent them through their children's guardian, who are from CAFCAS, but we have to go and visit our child clients. I advocate for always going to see a child, however old they are, not babies, but even young children. Many solicitors don't go and see them, but I think it's really important. And to understand their communication needs and to ensure that the guardian understands their communication needs. So if they require communication through visual means, or if they benefit from social stories and they need a certain level of preparation before the solicitor and guardian come to see them, that's all done. And the first thing I do when I've got a child who's gotten a diagnosis and got an EHCP, the first thing I ask for is their EHCP and their most recent annual review, because I know that will give me, not always very update, if you're nearly a year down the line since the annual review, but it'll give you at least some decent information about how that child presents and what their needs are. And one of the things I'm advocating for is that for all children who are neurodivergent, really it should be for all children, but particularly neurodivergent children, that we have all about me documents so that we can really understand who these children are and what their needs are, even before any assessments. I won't go on for too long because I can see Amanda's just joined, so I want to give her a chance to talk. But yeah, I mean, I could go on for all night basically about the way I've changed my practice, but if anyone's interested, then look at our autism ADHD page on Duncan Lewis's website, because you'll see some of the things we've noted there. It's brief, but you'll see some of the things in terms of the way we think we practice differently. And I think we are the first, we've said it, I think we are the first team in the UK that works in this way. So have a look.
Thank you, Alia. We will post the link. I would like to welcome Amanda Weston KC. Thank you so much for joining us. We really appreciate it. We've just been talking about threats and barriers to justice, particularly within Alia's field of family law and Matthew's in criminal. What do you see as the threats and barriers to access to justice for neurodivergent clients in your area of law?
Okay, so I do a few different areas. I did want to come back about the All About Me document. One of the key problems that Alia has identified is that if you don't have that document, when there's a new representative, it's like year zero. And so having a portable All About Me document for a child or an adult who has difficulties in accessing justice, who needs reasonable adjustments for effective participation. So having a document which really identifies what those difficulties are, not the diagnoses, but the actual problems faced, the obstacles to accessing justice, plus the solutions that have been worked out already, means that new people who come into that person's life, whether it's legal or professional, will have something to work from rather than reinventing the wheel and trying to, having to go through the trial and error process. So that's an important tool in accessing justice, because it means that everybody who's supposed to be making sure that that voice is heard knows how to provide that service to that client, whether they're a child or an adult. So I just wanted to say that is a fantastic document. Social services are used to doing it, and we've all seen those All About Me documents, but and certainly in the context of service providers to learning disabled service users, then yeah, you're going to see it, but I really can't understand why it isn't across the board. I know that there are moves afoot to amend the Equal Treatment Bench Book that judges have regard to properly take account of those useful sort of those learning points. You know what it's like when you go to court and it's all gone horribly wrong and no one's really taken the right measures in the so it's before you get to court. So at the point when you're assessing somebody and, can they access the process, however you're assessing them, whether it's parents or, whether it's children, whatever you're doing, at that point, it's so important to just have that have that means of effective communication. So I just wanted to sort of hammer that home. Really, it's really important. Judges, of course, aren't used to seeing those documents, but there's no reason they might not be expecting them, and they might look at you funny when you hand one up. But that's what we go through every time we have a culture change, and the culture change is what organisations like yours, Danielle, and the people who are presenting, that's what you are. You're in the forefront of a culture change. The other thing I wanted to say was, so it's right that there are already in place a number of adjustments which people are familiar with to effective participation. So whether that's the use of intermediaries, whether it's the use of screens or fidget tools, and lots of sort of things which we're familiar with and used to seeing in the courtroom, and that's one thing. But the particular issue that I'm struggling with at the moment is that individuals who have not been treated appropriately or not had their neurodivergence properly accommodated in school or in other environments are likely to have the sorts of adverse childhood experience which result in traumatized responses to everyday events. So what I'm talking about is secondary trauma caused to neurodivergent children and people by being treated inappropriately or by being treated pejoratively. And there are a number of overlaying features such as race and other protected characteristics which can also contribute to people's perceptions of the behaviours of neurodivergent people. So what I'm particularly anxious about is that we are all familiar with phrases like a trauma-informed practice, but my experiences, even in the family courts, they are way behind. So for instance, and this is a mechanistic problem, in the care context, the courts are very used to seeing young people who've been through the care system, then becoming parents, and once they're across the 18 threshold, the local authorities focus entirely on the children, and how those children might have been let down in the past becomes irrelevant. And so what I'm concerned about really is ensuring two things. When we're dealing with effective participation, we all ought to be, if we're running a trauma-informed practice, and I think most of us these days say that we do, we should be astute to the way that trauma and secondary trauma and emotional difficulties which might arise from inappropriate education environments for people, how that affects their behaviours and presentation and effective participation needs, but also, and I think this is important, poor coping strategies are something which can affect a person's ability to respond well to questions, whether that's questions in preparation of somebody's evidence to be a witness or taking instructions, or whether it's in the witness box. And poor coping strategies are something which are easily viewed pejoratively. So, for instance, if you've got a traumatized young person whose immediate reaction to feeling under stress is to lie, then you have to have a mechanism for ensuring that the courts factor that in, not just into how they treat the evidence, but how they take the evidence. And that I don't think we've reached that stage. There's a few evolved courts that you can appear in, and the judges of their own motion will say, yes, well, I recognise that trauma is a factor here, and they understand and they take it into account. But unless you've instructed a child psychiatrist or a psychologist to report on the impact of trauma on the witness's evidence, then there's nothing you can point to that's admissible in a family court. You'd have to make a Part 25 application. I think Alia knows what I'm talking about. And it's all very clunky, and it's not necessary because we all know what the effects of trauma are. All we have to do is identify that someone's trauma affected, and then make reasonable adjustments. So I whereas I'm sort of upbeat, I think anyone who's heard me before, I'm relatively upbeat about how court environments are becoming used to reasonable adjustments and effective participation directions. I still think there's a long way to go on trauma. And I'm very much hoping that changes to the Equal Treatment Bench Book are going to include some sort of visual explanations of how the brain works when you're in when you've having a trauma response, and the sorts of institutional knowledge that courts have to develop to make sure that those people aren't treated inappropriately as a consequence. That's what I had to say.
Thank you, Amanda. No, that feeds into my question, which will have to be my last actually, because it is now just gone 5:30. My question goes to Matthew and both Alia. Now, there are key provisions that professionals, judges can access, such as the Equal Treatment Bench Book, like Amanda said, the criminal procedure rules and the civil procedure rules. Matthew, how successful are those key provisions in minimising the threats and barriers, in your opinion, for neurodivergent clients?
In the criminal justice system, I'm sorry to say, ineffective. And I am genuinely sorry to say that. I don't doubt that you're right, Amanda, that there are steps forward, but I'm afraid they're small steps and they're inadequate, and they are too slow, and I'm critical of them. I think that the need here is simply more urgent and bigger. And so I'm afraid the Equal Treatment Bench Book is an example which is cited quite routinely by practitioners in courts as being important and so forth. And I'm afraid I just don't see the difference that's being made. I said earlier, Emma, and I mean it, that in my nearly 25 years of practice, I'm afraid the progress has been close to non-existent in this regard. And it's withering to say that, but it's true. And so I think the key provisions are way short of what is needed and by a measure. In my own part, in the criminal justice system, I would like to see urgent reform of custody facilities. I would like to, I haven't touched on the subject of prison conditions, but it's a fundamental part of the justice system, for example. I said earlier that I believe profoundly that the treatment of witnesses in the criminal justice system, those who are neurodivergent, is shocking. It's unacceptable, and that's wrong. And there are changes that can be made easily and cheaply. These things don't cost money, particularly, and I don't think they're as hard as sometimes they're made out to be. I think there's a huge responsibility on the judiciary to take, if we call them those key provisions such as they are, and take them seriously. I don't wish to be negative about that, because there's a tremendous amount of good work being done. But those pockets of good practice of the sorts that are being described by Alia and by Amanda there, I'm afraid are isolated. I hope there is change. I'm optimistic about that, but we're starting from a low base in my honest experience, and one that has not changed significantly. And I applaud all of you on the call for joining in and being interested in the subject. It is a start. I wish there were more of it. And it's not enough, if in danger of kind of being on my high horse about this. But it is not enough to pay lip service to the topic. Almost makes it worse. There has to be difference. And I'm sure Amanda and Alia's experience is similar to mine in these circumstances, that a judge may say something kindly and do nothing different. Well, that isn't progress. In fact, it's an excuse for a lack of progress. And there is a real challenge to those of us on the panel as lawyers to be genuine advocates in that broader sense, beyond the merely purely legal, to be real advocates for those clients who need that support, wherever they may be, in whichever of the systems we are each working in. And so I'm afraid those key provisions are inadequate, and they rely on good people, often parents, you've heard a bit about that, or lawyers or supporters or those in charities and in the third sector and so on, to stand up and to make a difference. And that absolutely involves an understanding of trauma, absolutely an understanding of the manifestation of a particular condition. It's not just a report. You may need a report. It's not just that. How does it make a difference? So for me, those provisions, I'm afraid, are inadequate, and there's a lot of work to be done.
Thank you, Matthew. And Alia, what's your experiences of the key provisions in your area of law?
I very much echo what Matthew and Amanda have said. I think, you know, there are mechanisms for reasonable adjustments to be put in place, but as far as I'm concerned, it all comes down to the person who is responsible for making the decisions of what adjustments are put in place, and for identifying those decisions, whether it's a lawyer representing a client and advocating for it, or a judge agreeing to it and directing it, to really understand the nuance and intricacy of the conditions that they're dealing with. And I can only talk for myself. I did not understand that before I had my son, who's autistic. And I'm not saying that every single person has to have a neurodivergent member of their family to fully understand it, but it comes down to training. That's why I'm advocating. That's why we've developed Flank, and that's why we're trying to drive forward this campaign for compulsory training of all professionals within, you know, as a starting point, the area we know, the child protection and the family justice system. It's, you know, as I mentioned earlier, it's being rolled out in the medical field via Paula McGowan, and it's starting to get a positive response. And so I'm hoping that if we can at least have a starting point of compulsory training, that we can build upon that and really help improve understanding, particularly amongst judges as well, because comments that I've heard when I'm in court, it comes across as ignorant, but it's because of lack of understanding and lack of training. And I'm not saying that I wouldn't have made similar comments before I had my son. And as long as we can all accept that before we had an interest in it and we educated ourselves, that we were the same as everyone else, we can hopefully bring people along with us rather than rather than coming across as criticising. It's about improving things. But it's not just about reasonable adjustments in court, it's about all the stuff that happens outside of court as well. And as a children's solicitor, I just find it really shocking that social workers and CACAS guardians don't have the training to be able to communicate with children in a non-verbal way. They should have, guardians and social workers do not have a bank of visual tools, of picture exchange communication cards, or now and next boards, or the ability to, or the apps that you can use to build social stories, that's just not readily available. And also the fact that foster carers don't automatically get trained in understanding these conditions. I always say, you know, whilst neurodivergence is not a medical condition, I always say you wouldn't put a diabetic child in a placement with a foster carer and not teach the foster carer how to treat the diabetes, right? And make sure they're monitoring it and understanding every aspect of it. But a severely autistic child with very complex needs can be placed with a foster carer who doesn't even know what the word autism means. I just think that that's really shocking. And, you know, last year I had a case where a very autistic child with very complex needs was placed with a foster carer, and it was an emergency application to remove her, quite rightly so, from her parents on an interim basis and place her in a foster placement. And considering how profound her needs were, the statement in the section where it says about what she needs in her foster placement simply said she needs somewhere where she can practice her faith. And so that, as a starting point, just indicates how desperate we are to try and change things and really just improve understanding. And so training's got to be the start of that. It has to be the start of it. And also, I mean, quite positively, the Family Justice Council have agreed that we need best practice guidance. And so Jenny Beck is leading that aspect of best practice guidance that's going to be drafted, and hopefully a first draft will be available before our flank conference. So that's really exciting. But again, I'm sure it will be something that's going to need to be worked on and built upon over the coming years. Yeah, and then, like I said, the systemic change, what seems like small things are actually massive things, like just having prompts to prompt lawyers to question whether their client might have an aspect of neurodivergence. All of that is going to be massive in helping to make the tools that we currently have actually effective and meaningful.
Absolutely agree. Thank you so much, Alia. I'm aware of the time, so we do have a question. Any hope of more transparency, RE training in the judiciary?
Yeah, I mean, I think there's certainly hope. And indeed, it's right to say, in my experience with the judiciary, that there are real pockets of really good practice and very strong practice. That's certainly true. And I find my own experience, the judges are very open to making appropriate adaptations, to taking into account neurodiversity when it arises in a case from whichever perspective it may be. My concern is that that's true when the issue is being properly addressed. But of course, that perhaps highlights the exclusion of those cases where it's not being properly addressed. It's not so obvious. It doesn't have a lawyer saying, Your Honour, deal with this, judge, deal with this. What are the experiences of those individuals? And so those barriers further down, I think, are particularly important. We've heard some examples about that, but there's certainly hope because there is good practice. And certainly I will leave judicial environments, sometimes court, meet, these sorts of things, and feel really enthused that you can do better. And there are good experiences. Perhaps they stand out too much.
So the Judicial Studies Board and the members of the judiciary that are involved with training the judiciary, I think, are astute to this issue. And certainly, as different parts of the profession start formulating guidance and developing learning points that are of broad application, I think that the judiciary will be even more likely to face requirements for training in those aspects. So I think that there'll be a groundswell of culture change, and then eventually the JSB and those other parts of the judiciary with responsibility for training judges will start making it a part of a part of judicial training and continuing education. Having said that, we're all familiar with you know, the phrase that you can lead a horse to water, but you can't make it drink. I mean, some judges just don't want to learn. But I think we've seen, certainly in the family courts, what happens to judges that don't want to learn. So brave litigation for judges that don't want to learn, if I can put it that way. I say that because I've got experience of litigating when judges perpetuate rape myths, or when judges perpetuate myths about coercive control. So I understand that sometimes you have to be a bit brave, and your client has to be brave about being critical. But those are the cases that change things. And so I think, in addition to sort of pushing judicial training, we should all be astute to rely on that learning when we're formulating our grounds of appeal. Yeah.
Thank you very much, Amanda. Thank you, everybody who has joined the call tonight for Understanding Neurodivergence in Law and Justice. But I just want to say a massive thank you to Matthew Graham, Alia Lewis, and Amanda Weston for giving up their time to come and talk to us this evening on this vital topic.